And just before we start the session, I would like to call on stage the keynote speakers to deliver the welcome speech and the special address. Dr. Masoud Vakili, Director of the International Intellectual Property Law Association USA, and Maria Theresa Trofaier, Senior of Counsel at DLA Pipers, Austria.
Thank you, everyone, and welcome to London. I know some of us were hit by lightning in a plane, but still made it, so that's very fortunate. So if it's meant to happen, it'll happen. So Maria didn't even land in Heathrow. She had to land in another airport, and she still made it, so we're very thankful for that. We talk about today's WLF event. It's the first one in London, so we're very proud of it. The Azam and Shirak and the rest of the guys and ladies have organized it. We're trying to foster international collaboration and in the field of IP mainly, but litigation is definitely an area of interest. And we're also trying to facilitate innovation in third world, or rather developing countries, especially in Africa and Asia. We have had some efforts already. The events we are holding, we're trying to limit the number of attendees to make it more intimate and close encounters and very good opportunities for networking. They're informative and very useful, as you'll find out. There will be a diverse group of people always. We have representatives from at least 3 or 4 continents and in all disciplines. And we'll cover a broad range of topics as you'll see. Today's program and tomorrow, the program will be a special address by Maria. Then we'll have a session by Richard from Nokia on managing litigation, which promises to be very interesting. Then the relationship between contracts and litigation, how it affects the contracts and go to litigation. And then enforcement of IP litigation, which I'll explain a little case that's very near to me, not from an occupation point of view, but from a geographic point of view. Then privacy and cybersecurity and data protection in relationship with litigation will be discussed. Alfred, Carlo, and Hugh. Then alternatives to litigation, which is very interesting subject, which managing disputes will be chaired by Ibrahim. And then the in-house litigation support and management, which is very important. I'll bring the case of Oracle America Inc. versus Google, which was recently decided back in the district court, and how the in-house management was affecting that. Tomorrow we'll have a session of emerging technologies and litigation, and finally the last session would be governance and compliance by Abhijit and Virginia, respectively, and closing notes by Mr. Azam Ghani of IIPLA. Now with that, I'm going to tell you about this case that I'm very interested in because one of these companies is just a few miles north of my house. The other one is just a couple of 3 miles south of my house. One is called Oracle, one is called Google. So in 2002, a couple of guys started writing codes that they later on called Android. They were writing it based on Java APIs, and they founded quote-unquote Android in 2003. In 2005, a company by the name of Google Inc., which is now Alphabet, acquired Android and started putting it into its platform. And in late 2007, I think November 2007, Google released the Android platform. Now, it's very interesting. The late 2007 is just a few months after the iPhone 1 release. So you could see what the motivation of companies are in this case. Then in November 2007, this was released, and immediately Sun Microsystems, back then existed still, congratulated Google on choosing Java API because it was an invention of Sun Microsystems. And they started negotiating on licensing terms, but it fell through. It never came to fruition. In 2010, as you all know, Oracle acquired Sun Microsystems. The price tag is very, very curious. It's about between $7 to $8 billion. And everybody was wondering, why does Oracle acquire Sun Microsystems, which is dwindling? Nobody is using Java anymore after, if you all remember, the dispute between Microsoft and Sun Microsystems, in which Sun Microsystems won the battle, but they really lost the war because nobody was using Java after that. So, but one possible explanation was that Oracle is a software database company, and now they're adding the servers, the Sun Microsystems strong servers, and they're offering software plus hardware. But sure enough, lo and behold, in 2010, some negotiations with Google fell through again, and they filed both for patent infringement and copyright violation at the same time in 2010 against Google Inc. In May 2012, the district court sided with Google, saying not only the patent issue is one of fair use, but the structure of Java APIs are not copyrightable. So that was a very curious decision. And obviously, Oracle appealed, and the Federal Circuit Court of Appeal sided partially with Oracle, saying that the issue of fair use must be remanded to the lower court. And definitely the Java API, the programming interface, is copyrightable. And the issue went back to the lower court. Now, a cert was denied by Google. Google wanted to take this to the Supreme Court, but was denied cert in 2015. And the whole trial went back to the lower court, to the district court. In 2016, the decision came out just about less than 2 weeks ago, and the court finally decided to side with Google again. That there was really fair use, and the copyright issue was not violated. Now, Oracle was saying, okay, if you have a function that takes 2 variables and outputs 7 variables, and doesn't matter what you call it, it's the same function. And that was a pretty good argument for my money. But there are several issues here that I'm sure some of it you all heard. We'll have a session on in-house management. There was an email from a top engineer at Google intended to be sent to Sergey Brin, the founder, and I think Schmidt, the other executive there, saying that there is no way we could do this without Java. There's no way we could run the Android platform without Java. And it was discovered partially because that email, even though it was had copied an attorney for confidentiality, it was never sent, so it stayed in the mailbox of that engineer. It was the sent was never clicked, and they discovered it just like that. And everybody's saying, with this email discovered, there's no way Google can win, but they still won. The second issue is the damages sought by Oracle. Curiously, about $8.8 billion, very similar to the acquisition price for Sun Microsystems. So now we could read back that not only they wanted to integrate hardware with software, but somebody promised, I'll recoup the money with this litigation from Google. So let's acquire Sun Microsystems. So these issues will be discussed, and then there's the other issue of jury and popularity in this case. On one hand, we have Google, which is the cool company and everybody likes, and when you're searching for something, you don't even have to type the whole thing. Halfway through your typing, Google knows what you're looking for and gives it to you for free. There is the issue of vertical integration. They lock you into a system. Fine, you don't pay for it. And by the way, you don't need Office. I give you a spreadsheet, document everything. And in the other side, there is Larry Ellison, who is really not a popular person. He is very arrogant. There's been many cases of misconduct. And the final jury in the district court in 2016 had 8 women and 2 men. So all these come into play of how this decision was made against Oracle. And many people still wondering, and we have not heard the end of it by any stretch of imagination. So with that example, which is very close geographical to me, I'll hand it over to Maria. Thank you.